In this video, we will talk about the Immigrant Worker Protection Act. The Immigrant Worker Protection Act, effective January 1, 2018, expressly steers clear of federal law with the use of the phrase, "except as provided by federal law." The Act added Government Code Section 7285.1, 7285.2, 7285.3, and Labor Code Sections 90.2 and 1019.2. The Act is enforced exclusively by the California Attorney General and the Labor Commissioner. It applies to private and public employers. Under California's labor law, employers are prohibited from requesting more or different work authorization documents than required by federal law, misusing the E-Verify employment verification system, threatening to file a false report with any government agency, threatening to contact or contacting immigration authorities. In addition, employers are legally required to comply with notice provisions informing employees of I-9 employment verification audits at the workplace, and notifying their authorized representative of the activity and outcome. Next, we will discuss each Government Code section in more detail. Government Code Section 7285.1 prohibits an employer or a person acting on behalf of the employer from providing voluntary consent to the entry of an immigration enforcement agent to any non-public area of a place of labor. This section does not apply if the immigration enforcement agent provides a valid judicial warrant. An example of providing voluntary consent to enter a non-public area could be freely asking or inviting an immigration enforcement agent to enter that area. This law does not require physically blocking or physically interfering with the entry of an immigration enforcement agent in order to show that voluntary consent was not provided. Employers are not precluded from taking an agent to a non-public area if employees are not present in the non-public area, and the agent is taken to the non-public area for the purpose of verifying whether the agent has a judicial warrant, and no consent to search the non-public area is given in the process. Government Code Section 7285.1 does not define the meaning of non-public, nor otherwise indicates that the term non-public should be given anything but its usual or ordinary meaning. A non-public area is one where the general public is not normally free to enter or access, such as an area where payroll, personnel, or client records are kept. Government Code Section 7285.2 prohibits an employer or persons acting on behalf of the employer from providing voluntary consent to an immigration enforcement agent to access, review, or obtain an employer's employee records without subpoena or judicial warrant. This does not apply to I-9 employment eligibility verification forms and other documents for which a notice of inspection has been provided to the employer. Government Code Section 7285.3 provides, in accordance with state and federal law, nothing in this chapter shall be interpreted, construed, or applied to restrict or limit an employer's compliance with a memorandum of understanding governing the use of the federal E-Verify system. Labor Code Section 90.2 requires that, within 72 hours of receiving a notice of inspection of I-9 forms or other employment records by an immigration agency, an employer must provide notice of inspection to each current employee and to the employee's exclusive collective bargaining representative, if any. This notice of inspection must be in the language typically used to communicate with the employees. See Labor Code Section 90.2 for what information is needed in the notice. Within 72 hours of receiving written notice from the immigration agency of the results of the inspection of the I-9 forms or other employment records, an employer must also provide to each current affected employee and to the employee's exclusive collective bargaining representative a copy of the written notice from the immigration agency that provides the results of the inspection of the I-9 forms and written notice of the obligations of the employer and of the affected employee arising from the inspection. Labor Code Section 1019.2 provides that, except as otherwise required by federal law, a public or private employer or a person acting on behalf of a public or private employer shall not re-verify the employment eligibility of a current employee at a time or in a manner not required by Section 1324A(b) of Title 8 of the United States Code. The Labor Commissioner established a business engagement program to provide training to employers regarding legal obligations. Email makeitfair@dir.ca.gov to request a training, ask a question, or report a competitor who is gaining an unfair advantage by violating California law. For more information on these topics, please visit the DIR website.